Welcome back, business law students. In our last chapter, we talked about personal property, things that you can move, or intellectual property. Today, we're going to talk about real property. Best way to think about that: land, houses, skyscrapers. This is real property. The way I remember that is to thinking it's substantial, it's real. You can't just pick up and move it. So let's jump right into some of our concepts on personal property here. Bear with me. I'm going to share with you. Thank you for your patience. Okay. These are examples of real property. Obviously, land and structure. You own your home, or you have a dream to own your home, and the underlying land and the house. That's a land and structure. That's real property. How about airspace and subsurface rights? Well, NSU, our university, happens to be based in Oklahoma, so a lot of people are somewhat familiar with mineral rights. In other words, if you own the property and if you bought clear title, 100, clear ownership, then you theoretically own the minerals underneath, gold, oil, gas, whatever's down there is yours as well. Some people are surprised to find that in certain instances you own the airspace above. Well, you can't control what planes go over, but that sometimes comes into effect. For example, you're a small house, you lived in a neighborhood zoned only for housing. Well, and then somebody next door tries to build a 5-story house and it stops the sun, etc., or they overhang onto your property or over your house. I mean, well, those are your rights and they can't be violated. Obviously, plant and vegetation is known as real property. Let's say you're living on a farm, you're growing alfalfa for cattle. Well, that's part of the real estate. But then, of course, after you cut it and bale it, well, then it becomes personal property. And like we talked about in our last chapter, fixtures. Easiest to remember that is maybe plumbing. You put a plumbing fixture in, it becomes part of the real property. Right. What kind of ownership interest can one have in real property? Well, you can have a variety of ownership, but one is called fee simple, and basically you own it. Uh, and so you might see fee simple, or if you ever buy a house, it might be that terminology might show up in the sales documents. You can get rid of it usually by a deed or by a will if you pass on, and you have exclusive rights and possession. Now, alternatively, you might have a life estate. So you only own the property until you pass away. Let's say, for example, you put your house in trust. You're so rich that to avoid taxes, you put it in trust for your kids or grandkids. Well, theoretically, you only own the estate in your home, the ownership in your home until you pass away, because then it immediately vests over to your children or grandchildren, however you set it up. Um, I want to jump. I found there's a few really good videos that cover up ownership interest. For example, it's the first one we're going to look at on, and that talks about leasehold estates. I think any of you who've signed a lease in an apartment, uh, this is going to be really interesting. Or if you do own a home, what rights do you have in that? So let me jump over here and share real quick. Bear with me.
There are different forms of property ownership, and each determines the legal rights and obligations of the owners. Those rights and obligations vary depending on the number of owners or the type of property. Let's take a look at some common types of tenancy. This is Kyle and Mary. They recently married and purchased a condominium in the city. This is an example of tenancy by entirety, which is a form of ownership by a married couple where the union is considered one unit rather than two individuals. They share equal ownership and obligation to the property as a married couple. Neither Kyle nor Mary can sell or transfer their ownership as individuals. This is Janine and this is Calandra. They are best friends. They've always dreamed of owning a house near the ocean and were finally able to when they both retired. Janine contributed 40% of the purchase price of the property, while Calandra contributed the remaining 60%. Although Calandra paid more for and owns a larger share of the property, the women have an equal right to use and enjoy the entire home. Years later, when Janine passed away, her will granted her nephew, Ethan, her ownership interest in the property. This is an example of a tenancy in common, which is an undivided ownership of real estate by two or more persons, in which individual ownership shares can be sold or transferred. Walter, Bill, Sam, and Dan are brothers. They own equal 25% shares of a fishing cabin on Eagle's Nest Lake. If one of the brothers dies, his share of ownership will be divided among the remaining brothers, making them each 1/3 owners. This is an example of joint tenancy, a form of ownership by individuals who have an undivided, equal interest in property. Upon death of a joint tenant, the interest passes to the surviving joint tenants, rather than to the heirs of the deceased. Joint tenancy may also be referred to as joint with rights of survivorship. While similar to tenancy in common, joint tenants must obtain the property at the same time, must appear on the same deed, and must own equal shares of the property. So, those are the 3 common types of tenancy. Tenancy in entirety.
All right, I think that video does a lot better job than I do of explaining the various types of ownership. And it's sometimes confusing to you because you'll hear the term tenancy or joint tenancy. That doesn't mean they're a tenant, like they at an apartment. That actually can mean they have ownership interests. It's just describing the type of ownership interest. So I apologize how confusing that is. Now, when we jump over that's ownership in property. Now let's jump over to just a lease. You're leasing your apartment. Well, just there are 4 types there. I'm just going to go through them real quick. You can look at them more in the text. So basically, a fixed term tenancy when you rent your apartment at NSU for a year, that's a fixed term tenancy. Periodic, tenancy at will, and tenancy at sufferance. So next, let's jump to a concept we call easements, and that's an interesting concept. So when I purchased my house, I found that when I looked at the drawings of my house, there was a line going down the side of my house, the east side. And I thought, well, that's funny. And it turns out they were easements where there was electricity, gas, etc., running under my property. And the natural gas company, the electric company, etc., had rights to run things on my property. That is known as an easement. An easement. I'm going to ease into your property. Now, let's look at a video that describes that, I think, very well. Bear with me.
Hi, this is Joe from Prep Agent. Today, we're talking about easements. An easement is a right held by one person to use the land of another person for a specified purpose, such as access to a property. When talking about easements, you'll hear the term ingress, which means to enter, and egress, which means to exit. An appurtenant easement. An appurtenant easement involves two properties owned by two different owners. The two properties involved are called the dominant and servient tenement. When you're not sure about who is who, just think about what the two words mean. Dominant, they are dominating, therefore they are in charge. Servient, they are serving, so the servient tenement is serving the dominant tenement's purpose. In more tangible terms, the dominant tenement is walking over the servient tenement's property. In real-world situations, the dominant tenement property is typically smaller than the servient tenement property. For example, let's say your property is landlocked. That means it has no direct access to a public road, so to access your property, you must cross someone else's property. That property is now serving a purpose to your property, so it has become the servient tenement to your dominant tenement property. The easement continues after you and your neighbors sell your respective properties to other people. An appurtenant easement attaches itself to a piece of property, so it is said to run with the land. This means that whenever a property is sold, the new owner has the same right to use the easement as the previous owner did. Under each state's statute of frauds law, easements must be in writing to be valid. Easement in gross. Another type of easement is called the easement in gross. An easement in gross has no dominant tenement because the people crossing the land are not using it to get to another property. That's why utility companies are common examples of an easement in gross. For example, the electric company may want to connect the power lines between two poles. If they need to cross your property to do this, they would be granted an easement in gross. Easement by necessity. An easement by necessity is created by a court. Easements by necessity are issued when someone must cross over someone else's land to gain access to their property. For example, let's say property owner Ann sells a back portion of her land to buyer Dave, but neglects to give Dave an easement for access. If Ann refuses to give Dave the easement, Dave can go to a court and have an easement by necessity granted. Easements by necessity are also considered appurtenant easements that will now run with the land. Easement by prescription. An easement by prescription is a type of easement created by the actions of one person against the interests of another person. Here's an example to explain how easement by prescriptions work. Every night when your neighbor Joe comes home, he drives his car across the corner of your property. You see him, but never stop him. And he does it for a long time. Eventually you get tired of him driving across your property and tell him to stop. But he says, "No way, I have an easement by prescription." Joe takes the matter to court and the court agrees with him. The fact that Joe's actions persisted over a long period of time are a big factor in the court granting him the easement. And now, Joe now has a permanent easement by prescription across your property. Easements by prescription are the result of a lawsuit, so a court order is required for them to be granted. The length of time a property must be crossed to create an easement by prescription varies according to what state you're in. You saw Joe cross your property, his use was open and notorious, which in legal terms meaning not hidden, is also hostile, which just means it was not in your best interest. By not telling Joe to stop sooner, you gave him implied permission to use your property, so the court granted Joe the easement. Terminating easements. Now let's talk about how to end easements. Easements can be terminated in several ways. You could terminate an easement with an agreement or release. The person who possesses the easement, also known as the dominant tenement, agrees to give up the easement or release it to the person whose property is being crossed, also known as the servient tenement. You could also end an easement by merging. For example, let's say Ashley has an easement across Brittany's property. Brittany then buys Ashley's property. The easement disappears since obviously Brittany would not need an easement to cross her own property. Next, there is abandonment, which simply means you stop using it. For one reason or another, you stop crossing the property. Unlike a dog, when you abandon it, an easement will cease to exist. On a side note, please rescue a dog. Last but not least, the need no longer exists. We discussed before how you could create an easement by necessity. Well, what if that need no longer exists? If you could prove that, then the easement will no longer exist either. This is Joe from Prep Agent.
Yeah, I think that is a really good explanation of easements and what they are. Basically, someone else doesn't own your land, but they have a right to cross over it, put lines in it, etc. Now, there are various non-possessory rights, a non-possessory interest in real estate. For example, you buy a movie ticket. Well, then you have the right to go sit in their theater, even though you don't own it. You might buy a license to hunt on somebody's property. So basically, the key here is possession has not transferred to you, but you have a right to use that real estate. Right. Instead of boring you with the specific details, let's jump down to, let's talk about transfer of title. But this again is another good video that talks about the concepts of transfer of title. And again, we're talking about real property. So bear with me. We're really getting to hear a lot from Joe, our real estate agent here in this, because he puts out such good, clear videos.
What is the difference between a deed and title? Most people assume that property deeds and titles are the same thing, but they're actually two different things that serve two different purposes. When studying for the real estate exam, most of us learn that title means ownership and a deed is evidence of the transfer. It is like when your mother packed your lunchbox for elementary school and she wrote your name on the box. That represented title to the box because it shows ownership. The receipt that your mother had when she bought it proves that ownership was transferred from the store to your mother, just like with a deed. The receipt is her evidence of the transfer. Let's dive in a little further. What is title? Let me start by saying that title is a concept, not a piece of paper. Title is the legal way of saying you own a right to something. In real estate, it refers to your legal ownership of a home. It gives you the right to live there and sleep there and use it as you wish. It may be a partial interest in the property or it may be full ownership. As long as you have title, you can access the land and enjoy it as you see fit. Title also means that you could transfer your interest or a portion of it to others. However, you can never legally transfer more than you own. In a nutshell, title is a concept used to describe a bundle of rights afforded to a homeowner or title holder. The bundle of rights include the right of possession, the right of control, the right of exclusion, the right of enjoyment, the right of disposition. The title to a property gives you the legal go-ahead to sell it again someday. But there's a catch. You cannot transfer ownership of a property until you clear title, which means that you've proven your title to the house is free of any clouds or defects such as liens, judgments, or bankruptcies. The buyer of your house and the lender financing the transaction don't want to take on any of your old debts that use the property as collateral. So to check for any potential problems before closing, a title search is performed. Any title issues identified in the title search have to be cleared before the sale can move forward. Common title defects include contractor liens put against your house for a kitchen remodel, improper title transfer due to past paperwork error, unpaid taxes, bankruptcy filings, child support liens, boundary encroachments, and many more. Until you can confirm the absence of any defects or resolve those that do come to light, you don't have a clear and marketable title to transfer to the buyer. That will bring your sale to a screeching halt until you can clear the issues and make your title marketable again. Abstract of title. When a sales contract is authorized, an abstract of title is generated that shows everything that has been recorded about the property at the county courthouse. The abstract of title often includes a summary of the original grant, subsequent changes in ownership, any encumbrances on the property, and a statement by the person preparing the abstract that is complete and accurate. Now that you understand what title is, let's talk about deeds. Unlike title, deeds are physical legal documents. The deed is the buyer's guarantee that the seller actually owns the property free and clear with no liens, encumbrance, easements, or clouds on the title. The deeds contain the names of the seller and buyer along with a complete legal description of the property. The deed is signed by the seller, generally in front of a notary public, in order to acknowledge the signatures. It must be a written document according to the statute of frauds. Sometimes the deed is referred to as the vehicle of the property interest transfer. You could transfer only a portion of your title, or you could transfer the entire interest. Deeds must be recorded in the courthouse or assessor's office to make them fully binding in most states, but a failure to file them does not change the transfer of title. It just means that the deed is not perfected. An imperfect deed doesn't mean that there's a problem with the title, but there could be a problem with the way that the deed paperwork was handled. Because it is a physical legal document, the buyer gets a physical deed in their hands at the time of sale, which proves they have title to the house. There are a few main types of deeds to note. General warranty deed. The general warranty deed is the most commonly used in traditional home sales and proves the most protection for the people buying your home. It means that you, the owner, have clear title and a right to sell the property, and you have no knowledge of any unforeseen issues that might come up with the title for the life of the property. It also says that no one else has the rights to own the property. Special warranty deed. A special warranty deed is similar to the general warranty deed with one exception. It only promises a clear title for the time you've owned the home. This is generally used for commercial real estate transactions and can also be called a covenant deed. Grant deed. Like the two types of warranty deeds, a grant deed shows that you have clear title to sell and no knowledge of anything that might impact the title. But it does not include a warranty that you will defend the title against anyone else who may pop up and stake a claim to the property after the sale takes place. Quitclaim deed. A quitclaim deed offers the least amount of protection for a buyer of your home. The quitclaim deed transfers rights and ownership to the buyer, but does not provide any guarantee that the seller actually has the right to do so. With a quitclaim deed, even if the seller is not legally allowed to sell the house, the buyer has no recourse after the sale because no warranties were made by the seller. For this reason, it's normally used when a property owner gives a house to someone they have a strong relationship with. For example, a father to a son. Bargain and sale deed. If your home was being sold in a tax sale or foreclosure, the property may be sold with a bargain and sale deed. This means that the seller does not need to clear the title and there are no protections for the buyer. So, for example, if there are liens on the property sold with a bargain and sale deed, they are purchased along with the property and the buyers are responsible for cleaning everything up after the fact. In conclusion, the terms title and deed are often thought of as the same thing, but their legal meaning is quite different. Once you understand the relationship between the two, you'll have a better idea of your rights and responsibilities as an agent, as well as a clearer understanding of the closing process.
Isn't that a great video that explains the different types of transfers? And again, title just means ownership, whether it's your car, whether it's a house, whatever. Title just means the right of ownership. A couple of more things, final things that, well, not final, sorry, I've got a few more, but whenever you're transferring title, you heard him once say that there are recording statutes. If you're selling or buying a house, you need to make sure that gets recorded in the county in which the real estate is. That's statutorily required usually. And it's also, the beauty is it puts everybody, the public, on notice that you're the owner, so somebody can't swoop in and take it from you. Also in one of the earlier videos, they came of the concept of adverse possession. Remember the guy that went across your land, drove across it for months, years? Well, that can be known as adverse possession. And I think the best example is your neighbor puts the fence on your side by a foot. 10 years later, you get a survey done and say, hey, wait a minute, that's on mine. He's got to pay to change it all. Well, your neighbor may argue, I have adverse possession rights in that foot of property because I actually practiced possession of that property. It was exclusive by me. It was open and visible, and it was continued for the period of time and adverse to your rights. And by what period of time? Depends on the state. 7 years, 10 years, depends on the state. But they can actually go after a number of years and if there's ever dispute, argue that they own rights to just that piece of your property by adverse possession. Okay, here's some interesting concepts. Eminent domain, inverse condemnation, restrictive covenants. Let me just say before we watch another video that looks at eminent domain and inverse condemnation very well. And you're probably going to be surprised that the government can take your land. They have to pay you a fair price, but they can take your land if they want to build a highway through it, for example. But first, let's jump to restrictive covenants. For example, I was in looking at some property for various legal reasons fairly recently and saw that it had the neighborhood of one. We were looking at restricted covenants on height. Well, it turns out that the neighborhood, since the restricted covenants were passed in the 1920s in Tulsa, Oklahoma, right in the covenants, it said that people could not, the land could not be sold to people that were Black or Native American. Now, obviously, those restrictive covenants are not enforceable today. They're against the law, they're against public policy. But there are other restrictive covenants. For example, in that land, you couldn't build a house above 2 stories. So if someone goes into a new neighborhood, doesn't bother to look at the land records, and then tries to build a 3-story house, they can get sued and be required to knock the top level off. So always beware of restrictive covenants on how land can be used. All right, let's watch another video that is actually pretty good on talking about inverse condemnation and eminent domain.
Inverse condemnation is an action by private property owners against the government when a taking of their property occurs. The power of the government to take the private property of a citizen to be used for a public purpose is called eminent domain. The broader category of eminent domain entitles the government to encroach on a variety of private property rights, such as those regarding air, land, and water rights. Under the Fifth Amendment of the U.S. Constitution, the government has a right to take property, but is required to provide the property owner with just compensation for the taken property.
Okay, so basically, oh, sorry, I got to turn off that video. Bear with me. So basically, surprisingly, the government come in and take your land, and that's known as eminent domain. You also sometimes have a right to come back and sue back the government to either take back some rights or restricted use of that land, certain use. Now, just a couple more things I want to talk about. The first is zoning. So you may own your land, but there may be restrictions imposed on that. For example, if you've ever read the newspaper about there's a big argument in front of the zoning commission. Well, your land will actually be zoned for what use? If you live in a neighborhood, it's usually zoned for commercial. If you are working in a place where there's a bunch of plants, it's probably zoned for industrial use. If you work at the mall, well, that's a commercial use zoning. And then there are also conservation districts where there might be set-asides for certain land. So again, you need to see if there are any restrictions against your land. Some restrictions, setbacks, you have to be so far back from the road, has to have visual aesthetics, et cetera, et cetera. One that the text talks about is adult businesses. So certain so-called adult businesses might have to be, 1,000 feet away from a church or a school, for example. Uh, then finally, let's talk about landlord-tenant relationships. We'll do this real quickly. Obviously, as a tenant, you have the right of possession of your apartment. You can use it and you have to pay rent, et cetera, et cetera. Now, when they transfer it, the only thing I want to point to is usually in your lease agreement, there'll be a provision that says you don't have a right to stop the landlord from selling it. And so if you ever been at whether it's a factory, a mall lease, whatever it is, sometimes when the owner sells it to a new one, you might get a certificate saying, yes, I'm a tenant here and I acknowledge that I signed this lease and there's rights to the new one and I don't have an objection to the new one. All right. That's it, my friends. You have suffered yet another chapter with me. And I think we're down to 2 lectures. So hang in there. We're almost there.